Joining us to discuss more about that civil enforcement mechanism in the bills this year is Representative Brent Crane, Katie Ball from University of Idaho School of Law, and Jeff Kohler, trustee from the Meridian Library District. I wanted to start with you and ask, for those who are completely unfamiliar with this portion of civil law, how does it differ from criminal penalties?
So when a state legislature wants to curtail or direct particular activities, they can of course do so with a criminal statute that prohibits it and provides punishment. There's also this civil enforcement mechanism that allows them to authorize private parties to try and basically enforce these types of laws. Most of them provide for statutory damages, so there's a particular set amount. Some of them allow extra damages for compensatory or other damages that someone has suffered. But it's really a way to avoid pre-enforcement review by a federal court. So if I think a statute that the legislature has passed is unconstitutional and I'm within the purview of that statute, my actions would come within that statute. I might want to go to the court and say, I would like to enjoin the state actor from enforcing the statute. So I want to keep the status quo until the court can really tell us if it's constitutional or not.
And we see that regularly,
yes,
where people sue to stop the enforcement of a law.
Yes, but that requires a state actor. So here we have private citizens who are enforcing it and obtaining these statutory damages. And of course the legislature has the power, right, to legislate in areas of health, morals, safety, so they do have powers to create these types of statutes. And in fact, in the Planned Parenthood case, the Idaho Supreme Court said that with regard to the abortion statute, that these types of civil enforcement mechanisms were constitutional and within the legislature's power.
Because we do have already on the books and upheld by the Idaho Supreme Court, as you said, a law that allows the family members of a fetus to sue an abortion provider if a woman does obtain an abortion.
Yes, and I believe the statutory damages in that case are about $20,000. It's just to provide an example. In Florida, they wanted to prevent harmful materials deemed harmful to minors. They wanted to preclude those from being included in school libraries. They went with a criminal enforcement route as part of that. So it's a 2 to 5 year felony if you're providing those materials in schools. Using the same language in the proposed Idaho statute, the harmful to minors materials, it came through with a civil mechanism.
And that was something that, similar to what passed the House in the 2022 legislative session, Senate didn't give it a hearing. It seems like this civil enforcement mechanism is more palatable, at least to some people.
Yeah, House Bill 666, I think, is what you're referring to with regards to the criminal penalties. The issue is with regards to obscenity statutes in the state of Idaho, that, you know, if anyone hands a child obscene material, they're subject to criminal penalties, except librarians. And so those that were seeking to remedy the situation in the 2022 session said, well, that's just easy. Let's just remove that exemption for librarians. And that passed the House with no problem, but when it got to the Senate, there were some concerns. And so this year they thought, well, hey, maybe a better way to approach the problem is let's look at this civil cause of action. And I think the first House bill started out, House Bill 139, and the civil cause of action was $10,000. By the time you got down to House Bill 314, it had been negotiated down to $2,500.
And 314 is the bill that Governor Little vetoed after it had passed both the House and the Senate. Representative Crane, you supported the bill. As we mentioned earlier in the show, Blaine Kanzati of the Idaho Family Policy Center had said during a February Capitol Clarity event that one of the thoughts behind this legislation, behind this enforcement mechanism, specifically was to affect insurance policies. In essence, forcing libraries to take some books off the shelves or move them if they didn't want an insurance provider to drop them as a customer. Did that enter into your consideration of the bill?
Absolutely not. And again, I'm the chairman of the committee that it came through. It was my brother's bill, but I did support the legislation and will continue to do so because it's my belief that these issues need to be decided in the legislature, and parents need to have the ability to go to the library and not be concerned that their child is going to be handed this type of, or checking out this type of material without their permission. And so from my perspective, all we want to do, and if you look at the legislation, it said, hey, we want the libraries to just take a reasonable attempt to make sure that this material can still remain in the libraries. We're not banning it at all. There was no intent to remove these books from the library, but just to make sure that it's in a section of the library that has access for adults, and the adults would make sure that they're getting that the parent or the guardian is getting that material to their child, if that's what they choose to do. There was no discussion until we actually, I think, got to Governor Little's office and talked about it, about the ICRIMP issue or the insurance issue.
And that's the state insurance provider,
yes,
ICRIMP.
Yeah,
right.
Exactly. So that never factored into the decision at all for me to support the legislation.
And Jeff, I wanted to get you in on the conversation as you're listening to this. This is, of course, not the first time you've heard these concerns.
Right.
What is the role of librarians in making sure that children aren't accessing materials that are age inappropriate?
Libraries are trained professionals. They've been doing this for generations. They have the tools and the ability to help every reader, regardless of their age, find the materials that are right for them and their family. One of the challenges of this legislation is it upends that relationship, and suddenly every librarian has to weigh that interaction with the public to say, is this a good faith actor coming to me in my library? If a 17-year-old comes to the library and says, can you show me where the Melissa Davlin novels are? And the librarian has to say, okay, it's not James Joyce, it's not D.H. Lawrence, it's not Toni Morrison, but I'm not sure what the Davlin novels are all about. Am I safe to give this teenager this material? That's the challenge for these people that are used to helping the public find the information they need.
I would never write anything inappropriate in my novels, to be clear. Did that insurance conversation come up in your conversations with fellow trustees in the Meridian Library District?
It hasn't yet, but it certainly would have had the bill passed. That would have been our conversation between now and July when the bill would have gone into effect, because we couldn't risk that liability, and we would have had conversations with ICRIMP, with our legal staff, and others to try to figure out how we're going to navigate this environment.
Representative Crane, Governor Little, in his veto letter, called it a library bounty system, essentially, pointing out that a private citizen could go and try to get $2,500, if their children successfully checked out a book with materials deemed obscene. I wanted to get your reaction to that.
Well, the governor obviously has his opinion on this issue, and we've had to agree to disagree on the issue, and that's okay. That's part of the legislative process. And a lot of people have asked, well, what do you think about this, now that the bill has not been successful? Typically, these type of issues take 3 years to work their way through the legislative process. This is only year 2. It got through the House, got through the Senate, and now the governor finally had the opportunity to weigh in. And it will be important over the summer to work with the governor and find out, hey, what are some of your concerns? How can we address those concerns? But yet also, 74% of Idahoans have said they want this issue resolved. And so, Governor, how can we do that, working with the House, the Senate, and the governor, librarians, to make sure that we can get this type of policy passed so that parents can ensure that they can go to the library and their kids are not going to, they're going to be in the 8-year-old section and have access to some of this obscene material that was shown at least in the House State Affairs Committee.
Katie, whether you think of it as a library bounty system or civil enforcement mechanism, had this passed, or looking at other statutes that have similar enforcement mechanisms, is this something that a private citizen can navigate without an attorney?
The court system's always difficult to navigate without an attorney. You have filing costs, and then there's, of course, the rules of procedure and the customary rules. We have a lot of people represent themselves pro se in court on a variety of matters. You're always a little bit better off, I think, with an attorney, just because they can have access to the cases, the statutes, and they know how the court system works. So,
but that, of course, adds to the cost, understanding that you might not win.
Yes. But I think there will be people who will test it and file lawsuits on it. And then it's, then the court's involved in deciding what's obscene, what is considered harmful to minors. And I know we have definitions in the statute, but really then we're going from librarians trying to make that decision to the courts and the judges trying to figure out, is this obscene or not? And of course, in the famous case, back from the 1960s, or when they were talking about pornography, the justice in that case said, well, I'll know it when I see it. So it's really who's going to make these decisions.
But those standards could be different depending on what community you're in. A book like Heather Has Two Mommies might be considered offensive in a smaller community that would be perfectly acceptable in a place like Ketchum or Boise. Does that concern you, that subjectivity?
No, and I think that was the beauty of the legislation, is to allow the local communities to decide what those community standards are. And that's one of the reasons that I thought that was a good provision that was put into it, because as you exactly highlighted, as a lawmaker, you represent your little town, your section in Idaho, but those values vary from town to town. And so allowing those community to determine what the community standards are, I think is very important.
Melissa, can I weigh in there?
Please.
So, but what if I move to Rexburg or I move to Coeur d'Alene? Do I have to check in with somebody at the city gates to say, hey, we got to make sure that the community standards haven't been modified somehow?
Yeah, so again, if that's what they want to have in Rexburg and that's different from Haley, then we're going to allow Rexburg to determine what their community
Right, but what
standards.
if I move to Rexburg?
Well, then you're going to have to, just like if you move from Oregon to Idaho, you're going to have to adopt the laws or the community standards of Idaho if you're coming from Oregon. It'd be the same thing within the state of Idaho.
And Jeff, I wanted to ask you, we have about 90 seconds left. You had testified when this was on the Senate side that if this and other bills had passed and stood, that you would recommend to your fellow trustees that the Meridian Library District rescind all cards to minors and also not allow anyone younger than 18 into the library without an adult. Understanding that this bill is vetoed, but the debate isn't over, is that still on the table?
Not at this time. We'd have to wait to see what comes out next year. But certainly if a similar bill were to pass, that would be certainly something we would discuss.
In just under a minute, when you hear things like that from trustees, does that concern you?
Well, again, the libraries were at the negotiating table when we crafted 314. And we conceded to 4 points, one of those around the issue of attorney's fees, making sure that there were no attorney's fees. The only area where we could not agree with the library was a penalty provision. I told them, I said, well, if someone violates a law, there has to be a penalty. If you sell cigarettes to an underage kid or you sell alcohol to an underage kid, there's going to be a penalty for that. And so there will have to be some penalty for if there's a breaking of the law. We're going to get this issue resolved. So I want to let parents know we're working hard. We will get this issue resolved, and I remain optimistic it'll happen in the next year or two.
Okay, we're going to have to leave it there. Representative Crane, Jeff Kohler, Meridian Library District, and Katie Ball, University of Idaho, thank you so much for joining us, and thank you for watching. We'll see you next week.